Hello, my name is Mike Tesoro, and this is the cheat sheet for May 2026. I'm doing it a bit late, but I'm actually catching up quite nicely. What this is all about is basically summarising all the ACCC developments which occurred in that particular month, so it saves you the trouble of reading all these emails, all these media releases. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to Legal Consulting for the last 20 or so years. I help companies, individuals with competition and consumer law problems. Also help some legal publishers with consultancy advice on competition and consumer law, and have a part-time role as general member of New South Wales Civil Administrative Tribunal. So that's a good role. I get quite a lot of hands-on experience with Australian consumer law claims. Prior to that, I worked at the ACCC 15 years in a variety of roles, including in charge of enforcement and mergers in Sydney, or one of the people in charge of enforcement. Outline one court case, a couple of enforcement matters, a product safety, a product's been banned, doesn't happen every day, some authorisations, and two other issues. The big case, obviously, in May was the Coles down case, and as everybody knows, Coles went down. They lost the case, and this was sort of expected. I think it's a funny scenario. Listening to the media coverage during the trial, you start thinking, oh, maybe the judge is not going to find a breach. He's making a few challenging comments to the counsel for the ACCC, and you're thinking, oh, maybe he's not going to find a breach. But I think when you go away and you think about it and you read the evidence, you realise it was always going to be a breach. So what the court concluded was, in relation to these 245 common products sold, ACCC alleged that Coles increased the value of these prices for a short period of time and then reduced them and claimed the price had gone down. And so that was the whole essence of the case. Products that were at a particular price were increased for a period of time to create a higher establishment price and then reduced. And in some cases, they weren't reduced below the price at which the good was sold before. So impressionistically, it looks very misleading. But there's a bit more to it than that when it came down to it. ACCC made a big play in the case, saying they were illusory discounts and put that very on the table. I guess they were almost suggesting it was an intentional strategy by Coles to mislead people. And effectively, they did a sample of products and didn't do all 245, did a sample, and 13 of the 14 products were found to have been misleading in the fact that the down price was not established for a reasonable period of time. So here's some of the judgment. So in paragraph 37, he's concluded the down tickets conveyed a representation to ordinary consumers that Coles had reduced the price, and implicitly that reduction was a genuine discount. And then he speculates as to what the ordinary reasonable consumer would do. I don't know if judges are the best people to speculate about this. I'm too sure they're big personal shoppers. I imagine most of them purchase their stuff online. I don't really know, but anyway. The vast majority of ordinary shoppers would not have formed a conscious belief about the period for which the product had been offered, but had an intuitive sense that the product had been discounted for some period of time, and that was a genuine, not artificial discount. And incorporated into within the notion of genuine discount, was how long it had been offered at that higher price. Then in paragraph 38, in assessing whether, I guess a was now price representation is misleading, have to consider a range of factors. So I guess he lists there a few commercial circumstances in which the price of the product has been increased. Was it responding to competitive pressure or something like that? The level at which the was price was set, the period for which the product was sold at the was price, and how many products were sold at the higher price. So they're all the facts you have to weigh up in relation to each of these products. So having looked at it all, he concluded the price increases all resulted from supplier cost increases. They were commercially justified. Now, I think the reason he said this was because the ACCC did strongly suggest that maybe there was a bit of price gouging going on and cynically increasing prices. And I guess he wanted to address that submission, but really he shouldn't be even commenting on this. It's not relevant. He's not there to determine whether Coles had a justifiable reason for increasing the price. So he's gone a bit off off the plan there. He shouldn't be commenting on this, but he couldn't help himself. And what happened after he issued his judgment, Coles latched onto this particular statement by Justice O'Brien and said, "Hey, look, we were justified in increasing our prices." So I think he strayed into an area he should have strayed into. Then he concludes, and this is at paragraph 42, having a look at all the different things he believes that the product should have been sold for a period of 12 weeks. That's the establishment period. And if you had set it for 12 weeks at a higher price, the conduct would not have been misleading. And then all of the cases, or the test cases that hadn't been achieved, had all been for different periods of time, some closer to 12 weeks, some very short periods, but none had been done for 12 weeks. So he's concluded that. Now, the thing that's interesting here is this 12 weeks is a very arbitrary number. It's obviously what Coles did internally, and I think Woolworths did the same thing internally. And I think what he sort of suggested is that, well, here are business people, and they think 12 weeks is an appropriate establishment period, so I'm going to go with that. But I don't know if it's really correct, because there was some other case law, and this is what a lot of competition and consumer advisors look at, is 28 days, like 4 weeks. And there's been a bit of case law on that, and that's generally what advisors tell their clients. A 4-week establishment period is about right. It's not too short, not too long, a bit like the three bear scenario. But I guess the fact that Coles and Woolies both had 12 weeks, I think O'Brien said, well, if they think it's 12 weeks, it should be 12 weeks. I think 12 weeks was erring on the side of caution significantly. It is very, very long, particularly for these type of goods. Like these are goods you buy every week often, and it seems 12 weeks is a very long establishment period. The question is, if it's a purchase that you make every week and you've got to establish for 12 weeks, what does it say for people selling more expensive products like fridges and TVs? Like, how long have they got to establish a product price for? And I think it's created a bit of confusion in those more irregular purchases. What's the establishment period? If it's 12 weeks for groceries, should it be 120 weeks for more expensive products? So he's come down to 12 weeks. I don't think there's any real, scientific basis for that conclusion. There's no survey data of consumers which says 12 weeks. I think he just made the conclusion. Coles and Woolies thought it was 12 weeks. Then they changed it to a short period of time due to competitive pressures, and so I'm going to make them go back to what they were doing initially. Then he looked at some other issues that. Oh, this is a conclusion at 458, I should say, saying that if the was price had been established for a period of 12 weeks immediately preceding the down price, that would have been fine. Conversely, if the ordinary consumer told the product had ordinarily been sold at Coles at it was price for a period that was, and this is interesting, materially shorter than 12 weeks, they would not have believed it was a down price was genuine. So the problem here, is it 12 weeks or is it a period that's not materially shorter than 12 weeks? So these are the kinds of confusion that the judgments cause. I think everybody's going with the 12 weeks as a guide, but here it's suggesting that if it's materially shorter, maybe 11 weeks, maybe 10 weeks, maybe 9 weeks is getting materially shorter. I don't know, but it does create a level of ambiguity in this decision. This was another interesting thing. He dabbled with intention, which I don't quite understand. A lot of people did see this paragraph and scratch their head. Although the meaning conveyed by the conduct must be ascertained objectively, which is sort of like, Consumer Law 101, the intention of the representor may be relevant. Specifically, a representation is made in terms apt to create a particular mental impression in the representee and is intended to do so. It may properly be inferred that it had such an effect. So TPG case, and then he refers also to TPG case and Bed Bath and Table, which is quite a recent judgment. And there's a lot of talk about intent in those cases, but the thing I don't think it necessarily capturing is these other cases have talked about intent being relevant as an evidentiary thing, not in terms of proving something's misleading on its face, like they intend to mislead, that's going to make it a breach. Rather, it's you can infer from intent. So if we're intending to achieve this particular outcome and there's documents saying we're intending to create that outcome, a court can infer from that evidence of intention what what the effect on the consumer is going to be. So I think this is a confusing passage, and it seems almost like he's trying to bring intention back in as a relevant consideration when considering breaches of Section 18 of the Australian Consumer Law. And I think when you look at the immediately preceding paragraphs, it is talking about looking at intention as having some evidentiary role to play. Here's another observation, again, an observation that I don't think he should have made. As is apparent from the reasons of judgment, the conclusion I reached is relatively narrow. So saying don't go rushing out and saying this is the be all end all. Fortunately, that's exactly what people have done. The down tickets were misleading because the sample products had not been offered for a reasonable period. If Coles had offered the products at the was sale price for 12 weeks, the down tickets would have been fine. This observation raised the question whether consumers were harmed. Now, here he's sort of jumping ahead, and the interesting thing here is this was a dual proceeding. There was the ACCC proceeding and a class action hooked on together, and both cases will have to be determined ultimately when it comes around to the remedy stage. ACCC is going to be going for a big penalty, probably a couple of $100 million, and the class action is going to be seeking a big payout compensation for consumers. So he's saying, I don't know if any consumers were harmed, which really shouldn't be talking about that at this stage, I think. And then he opines that if Coles had offered the sample products at was price for 12 weeks, then consumers would have been arguably in a worse position. So it's like saying, okay, we only had them at the was price for 1 week, and then we reduced it by $2. So people got the benefit of 10 weeks of the lower price. But if we'd had it at the higher price for 12 weeks, then those consumers would have paid an extra, $2 for 10 weeks. Now, this just totally misses the point. Like, the consumers who are looking for the down bargains are maybe not the same consumers who are buying things at the full price. That's the point he misses. This is all about the consumers who are using the down tickets as a guide, as a cheat sheet to work out the best prices, the best value goods to buy. They're using that to help them navigate a big store with thousands of items. What am I going to buy? What's a good buy? Well, Coles is telling me this is a good buy. This has been reduced from the usual price. I'm going to buy this. So this analogy that he's putting here is just wrong, because effectively he's saying the class of consumers who don't care about down would have paid more if the price hadn't been established for 12 weeks. But they're not the same people who are going to be buying the down products, and they're sort of different people. Obviously, there's a bit of overlap. Like, some people love a particular product and decide to buy it regardless of whether it's on special. But I think, the majority of people are pretty agnostic when it comes to products. And if they see, chips down, they'll probably buy that. Cheese down, they'll buy that. Certain people, like, if you're a Coles drinker or a Pepsi drinker, maybe you're not going to be so willing to choose the other product. But the thing he's missing here is you have a class of consumers who are value conscious, who are looking for the down, and have a right to believe and trust Coles that the down actually does tell them something meaningful. And the problem here, it didn't tell them anything meaningful, because it was purely arbitrary what Coles decided. Oh, here we're going to have it for 4 days establishment. Here we're going to have it 8 weeks. There was no rhyme or reason to it. So you couldn't trust the prices. They could have meant anything. So I think it's a right decision. I don't know whether Michael O'Brien's going to fine them what they should be fined for this conduct. I just get the feeling that maybe he might not fine them as much as they should be fined. He's got a reputation of being a big fine. He did fine BlueScope $55 million for an attempt. It's a competition case, but that's going to come back to the court in the future. And also you've got the complication of the class action, what's going to happen there. And obviously the Woolworths case is coming down sometime in the future, which was also Justice O'Brien. And there's just no way in the world that Woolworths can't lose. Like, it just wouldn't make sense. And I think probably Woolworths' conduct a bit more egregious than Woolworths' case, than the Coles case. So it'll be interesting how it pans out. But I think Woolworths must be getting ready to lose the case. There'll probably be appeals here. I think whilst he didn't write an extraordinary amount, he did say a few things that seemed a bit strange. Just seems to me that if he got anything wrong or he said anything he shouldn't have said, it's probably negative for the ACCC in a sense, and for the class action firm. I don't know if he said anything that was particularly legally wrong in relation to Coles. Coles had a bad month. They actually got hit with some infringement notices as well in May, and this is in relation to the Dairy Code, which is pretty complicated stuff, I've got to say. It is very prescriptive and you can make mistakes fairly easily. So Coles and Browns both paid penalties, infringement notices for breach of the code, alleged breaches because don't admit a breach under an infringement notice. ACCC claimed that Coles had breached the Dairy Code by publishing two separate milk supply agreements that required the supplier to provide milk exclusively to Coles, while also imposing a cap to maximum volume of milk that could be produced. Now that's elementary breaches, and how is Coles making those mistakes? I don't know. Separately, Coles alleged that Browns breached the Dairy Code by publishing two supply agreements that did not clearly specify the minimum prices that applied throughout the entire supply period. Now that's not such a big breach. So the Coles breach is I've got to say, a real no-brainer. The Browns was a little bit more sort of technical, I guess, but they both got hit with infringement notices. Amazon enforcement got taken to court. They've had a bit of a bad run. There's been three cases, a couple more coming up. But this one is the first legal proceedings commenced about two important issues. Firstly, you've got an intermediary who's selling on products that don't comply, allegedly, with a mandatory standard. So usually the intermediaries between the supplier and the consumer have been sort of immune. But that's not the way the product safety laws work. You know, if you're in the middle of transporting goods that don't comply with managed standard, you're liable. So it's an important case there. And it's also the first, well, I was going to say the first case on button batteries, but I don't think that's right. I think that was City Beach, wasn't it? So it's probably the main thing. It's an intermediary who's been sued. Obviously, Amazon's been corresponding to the ACCC, and they don't believe they should be liable. I assume that's why it's going to court. Could be going to court because ACCC wanted a big penalty, and Amazon didn't want to pay it. I don't know. But as it looks at the moment, it's going to be contested. ACCC alleged that Amazon had possession and control of these little backpacks at a period from June to November 2022. And these required labels because they had button batteries in the products and they didn't have them. And they only sold 41. That's not, we're talking multi-million dollar breach, alleged breach, but they were purchased by various consumers. So they're buying these through Amazon from sub-manufacturer. But the question is, should Amazon be verifying that these products are fine? Of course they should. If you're going to make a margin, they're not doing it for free. It's not pro bono operation. So they're making some money from selling these products on behalf of suppliers. So they've got some duty of care. So 41 backpacks were sold. Doesn't sound like a big seller. 267 were in their fulfillment centres. So it's going to be an interesting case. And I don't know, maybe Amazon want to fight it. The principle is important to them. If they're going to be liable for every product they sell in this way, it's going to be a big impost on their compliance. So they might want to take it on, see if they can, I don't know, avoid liability or at least get some narrower guardrails about what they've got to do. Bottle feeding devices, the ACCC has been looking at this for a while, and these are devices that help you feed your kid, without you really having to be present or at least observant of what they're doing. And the ACCC did a review and concluded that these were dangerous devices. So there's a ban being imposed, and so they're just any products that position a baby bottle, a bottle teat, an infant can self-feed without another person holding the bottle or without adult supervision is now banned. Obviously, the risks of injury and death, and it's illegal to supply those. Here's some examples of them. I've never seen them before. I don't think I would have ever used them anyway with my kids, but obviously they're in the market, and there's a concern that the child, might choke if they can't regulate the inflow of the milk. Authorization. So this is an interesting thing. The ACCC sort of got some temporary emergency exemption type powers during, or fashioned some during the COVID, and they were quickly approving various arrangements to make sure products were available during the COVID period. And I guess the government thought, well, we should give them this power going forward. So now they've been given this streamlined competition exemption power to respond to emergencies. And so legislation was passed, the Competition and Consumer Amendment Responding to Exceptional Circumstances Act, to fast track competition exemptions for businesses which urgently need to coordinate. I think probably the Middle East war has also contributed to the view that this is a needed power that the ACCC has to have. So you can see critical products need to be supplied during national emergencies, and effectively it's triggered by a declaration by the government under the National Emergency Declaration Act. So the government says, yep, National Emergency Declaration Act is invoked. There's a national emergency in relation to these areas, and then those players in that area can apply to the ACCC to get any arrangement approved quite quickly. Authorisations, a couple of authorisations. The first was the Australian Hoteliers Association. These authorisations have been around for a long time, so there's nothing really very controversial. They've been given an approval in the past to collectively negotiate with hospitality suppliers, and also to enter into and give effect to contracts, arrangements, and understandings with those particular organisations. And so the ACCC is proposing to grant a new authorisation for this conduct, which has been around for years. Air Cargo Alliance, so the ACCC is proposing to grant authorisation for a number of air cargo companies to work together, and I don't think this is such a great idea. It's an industry where there's been price fixing in the past, and I think you want to let people get together. But anyway, it's a proposed authorisation. IAG Cargo, MAB Cargo, Qatar Airways. I really haven't heard of anybody at Qatar. And I wouldn't say these guys, as far as I can recollect, were involved in earlier illegal conduct. But it's an industry where there's history, and I don't know, authorising people to get together where there's been collusion in the past, I don't think it's a very good idea. And I keep them far apart as possible. Here's another one, New Energy Tech Consumer Code. This is actually a draft determination to continue approving this particular code. Effectively, the Clean Energy Council, the organisation which administers this code, and it's a voluntary code, but bordering on mandatory, I think, really, when you think about it. And it sets minimum standards for good practice and consumer protections in relation to the supply of energy products, but primarily solar products. It's very elaborate, very involved. And I guess I had a bit of involvement here, a few clients to do a lot of this work, and I put a submission into this code. I thought it was pretty good. I wasn't too sure about the Clean Energy Council being the administrator. I haven't got a high opinion of their conduct in the past. But I guess that they have it, seems to be going okay. I guess the main thing is so much regulation in relation to solar power. Like, it must be the most heavily regulated energy source in Australia, like incredible amount of regulation. So I don't know if that's good. It seems to be probably the major future for renewable energy, particularly with the batteries coming in. And to regulate so heavily just adds a lot of cost. So I don't know if it's a good idea. But anyway, it's going to get approved again. It's been in. Maybe there's an opportunity to sort of cut back on some of the red tape, make it a bit more transparent too, particularly when they make these, determinations under the code. Australia Post, there seems to be a forever and never-ending series of requests, but here the ACCC has announced it's seeking feedback on some proposed increases on the cost of postage, proposed stamp prices, and this is because they had this, I guess, monopoly for years and years and years where they're making money hand over fist, and now with emails it's not making any money, and so they're just losing money. So they've got to keep pushing the price up all the time, and they're going to keep doing it every year, and it's just, I guess, a waste of time for everybody, really. I guess there are people who still like sending letters by post, and so they're proposing pretty big increases, and these just, they sort of keep them from losing money in the current year, and then they'll do another one next year, and it'll keep going this way. So it goes out for feedback, comes back, ACCC make a recommendation, probably will say yes, and then the minister has to decide. A couple other things. There was Law Council of Australia Consumer Rights Forum, which I don't remember that being run previously. Maybe it has been. But the main interest there is that Catriona Lowe gave a talk about, or the keynote speech at that particular event, which I think was in Queensland, and covered a few topics. Obviously, the flexible provisions under the consumer law, strong enforcement, penalties going up and up and up. It's all news, good news to the ACCC. Big focus on protecting vulnerable consumers, First Nations people. So that's all good stuff, and need to be really looking at that. And if you look at the case they've run, I think they tick that box. Then you have the National Anti-Scam, what's the C? What does C stand for? But Centre, that's right. So talking about the Scam Centre, which would be a big success, particularly fusion cells where they get people together to look at a particular topical issue, and the Scam Prevention Framework, which is making its way forward, going to be very elaborate, very detailed. I'm curious whether it's going to really achieve a whole lot. But it's going to be a lot of work required there to set up these various frameworks. Product safety, mandatory standards and unsafe products in digital markets. Well, that's interesting, because clearly the Amazon case is the one we talked about earlier, which has, Amazon, digital company, digital marketplace, selling products that are going to be liable for what they're sending out. Product safety is very big focus of the ACCC, very strong on enforcing all their mandatory standards, and also looking at new areas that need to be subject to mandatory standards, like the button battery and the toppling furniture and the quad bikes are all relatively newish standards. The unfair trading practices reforms, which has been legislated as far as consumers goes and comes into effect in the middle of 27, and most likely will introduce similar reforms in relation to small business contracts or transactions. Questionable whether it's entirely needed. Most of the things that have been proposed in the government's consultation paper are probably covered by existing laws, but I put a submission in one of the committees I work on, and we identified a few areas which aren't covered by existing laws, which we think are unfair. So we've sort of given them a few ideas of areas where they can actually say, hey, these areas aren't covered by existing laws and they're pretty unfair. So I think there's a bit more justification maybe in the business space for some of these laws. More work to be done in other areas. This comes out of the designated complaint they received about unsolicited sales, lead generation, subscription traps. ACCC is strongly the view that there's still too much wrong going on in that area. I don't know whether new laws need to be passed. It's just, it's a lot of enforcement, and, do they have the resources to do it? But I think what's being said in this speech is maybe need some more powers to combat some of the conduct. So I don't know what they'd be proposing there. I think there is something coming in the next little while where they try to put a bit more meat on what they're wanting here. But they reckon that's a big problem, and they need to stamp down on it with some new powers. And then working together to improve the law and consumer outcomes. So I guess, let's work with business and people to do things. But ultimately, I don't know if it really is that. I think, talk to the government. The government's got a pretty strong view. They want to bring in some law. They bring it in. And then business complains, said, hey, compliance costs, blah, blah, blah. And so I don't know if you really work together. I think it's more a case, work with government. Government thinks it's important, bring it in. And then you sort of work with the ACCC in understanding how the law's going to work, understand the priorities. And that should be there. Okay, so that was last month. More money. The final slide is effectively that ACCC has been given some more money. Not a huge amount of money, $67 million, but obviously good over 4 years. So it's it's not like 67 a year. That's going to help them a bit, because I think they were struggling a bit with all the work they were doing. Things do take a long time. They've got some big cases which must be draining a lot of resources. That MasterCard case is really costing them a packet. So I think, and the thing is, they don't get the money back. So they win a case and there's a $100 million penalty. It goes to the Commonwealth Government, the consolidated revenue, even the costs. If say they get an award for a couple $1 million worth of costs, they don't get it. It goes back to consolidated revenue. So I don't know quite why. I can understand the penalties, but I think the cost should go back to them maybe. and then they'd be self-funding, but I don't know quite why that doesn't happen. But 67 million, that's welcome. I'm sure they asked for a lot more than that. And then the federal budget did include a number of other areas that ACCC has to work on. Guidance materials, education campaigns ahead of all amendments. So clearly the unfair trading practices laws. And this is the thing, penalties for non-compliance with consumer guarantees. Now, that hasn't been legislated yet. There is a consultation paper by Treasury saying, yep, we're going to change the law in relation to consumer guarantees, and it hasn't surfaced yet. So obviously the government's pretty confident there's going to be changes there. Develop nationally consistent safety standards for e-microbility devices, which are just sprouting up everywhere. A lot of people are getting injured and killed, so it's important to try and get on top of that. Continue the National Anti-Scam Centre's activities, big job. Continue the digital ID regulator for further 4 years, so continue that work. And also good to see, consumer data right. It got put on hold a bit by the government, and that was a big problem to do that, because it's going to bring a lot of benefits to markets and consumers. And so good to see the government getting that back on the rails again. In terms of the commentary, Coles goes down. I guess that's a pretty obvious pun, but I think they would have got a few moments where they thought they were going to win. I think it reminds me of stories I heard about the Arnott's case, which was run, 40 years ago, and Arnott's were trying to buy Nabisco, and I think it was a clear breach. But they were doing pretty well on the trial, and they sort of started thinking, gosh, we're going to win this. And I think the judge Beaumont went away and looked at them and said, no, they're going to lose. Same thing here. I think maybe he was a bit persuaded by some of the arguments, Justice O'Brien. But then when he went away, thought about it, and wrote his judgment, he realised it's a breach, and so he found it was a breach. The judgment is a little bit unclear. Why the 12 weeks was chosen, not really clear. And then, as I said before, that thing that if it's materially less than 12 weeks, it wouldn't mislead a consumer. So what does that mean? So it's very vague. It's created a lot of confusion. And I think fundamentally 12 weeks is what the two main retailers were doing. But that doesn't mean that's a reasonable period. That might be they were erring on the side, abundant caution. 12 weeks seems mighty long to me. I think 4 weeks would have made more sense. But that's not the way it panned out. And I don't know if that's the kind of issue that on appeal you could say he got wrong, really. And it'd be hard to say that 12 weeks is wrong and 4 weeks is right. I'm just surprised you can go with a shorter period. Amazon litigation is going to be interesting. It's a big deal for Amazon if they're going to get sued for all the products they sell that might not comply with some law, particularly product safety law. So I think they might take it all the way, because realistically the precedent there is not good. Emergency authorisation power is a pretty good idea to bring in something a bit more easily triggered and able to streamline competition assessments of collaborations where there is an emergency. I think the Middle East war really highlighted the need to do that super quick. And the Australian Consumer Rights Forum was an interesting event. The keynote's worthwhile reading. And it's sort of, I guess, hinting that ACCC has a very receptive government at the moment. It seems to ask for new powers and he gets them. So I think it's going to be asking for new powers in relation to these subscription lead generation and things like that. That was an inference of the speech given by Catriona Lowe, that maybe some more legislation needs to be provided to them, and the government seems to like to say yes. I think the other thing that might be interesting to keep an eye on is the unfair trading practices laws for corporations, to see if that gets through and to see the form it takes. So the big argument there was whether it be like the Section 3 qualification, which is, as you know, $100,000 household, domestic, commercial use, that sort of thing. So that'd limit the application of UTP laws to anything under 100,000 effectively, or alternatively use the unfair contract term requirement, which would be like 100 employees or $10 million. The second makes more sense, I think, and that's what we submitted to the government, that should be the approach taken. But I guess if they choose the first option, the $100,000 is going to be much less application. If they choose the second option, it's going to have much broader application. Anyway, it's going to be interesting. So if you've got any questions, feel free to give me a call or drop me an email, and hope you enjoyed this talk.